India is set up, all these things. We have to analyze how judiciary is set up in India. Okay, for that I will give you one flow chart. Okay, now this flow chart is not just for judiciary. This flow chart can be applicable for all other organs of government, that is legislature, executive and judiciary. All these things can be done using this flow diagram. Okay, so if this is Lok Sabha, in India there are two bodies in Parliament, Lok Sabha and Rajya Sabha. Okay, so from these two bodies we choose Prime Minister plus Council of Minister. Okay, executive is taken out of legislature in India. So this body is headed by a person called as president. Okay, this body is headed by a person called as president. Okay, now this this is union executive. This is union executive, and this is union legislature. This is, of course, Rajkumar, it is very helpful for your law entrance exam also. It is very, very helpful for your law entrance exam also. Okay, this is union legislature. Within union legislature, we are taking out union executive. Why is this happening? Why is this? If you look at this one diagram, it says that executive is within legislature, meaning executive, that the ministers, the home minister, prime minister, all these persons are members of Lok Sabha or Rajya Sabha. Only then they can become executive, because India follows parliamentary form of government. Okay, so this is how a legislature and executive is set up in India. Okay, and president is a part of both executive as well as legislature. But okay, now below, now this is union government. Okay, this is union government. Now below union government there is state government, and state government is headed by governor. State government is headed by governor. Even in state government there is state legislative assembly and then state legislative council. Okay, so out of these two bodies, now state legislative council is compulsory and this is optional body. If state government wants that, they can have, or they cannot have that. Out of these two bodies we have chief minister plus council of minister. Now this is state executive and this is state legislature. Of course, this will also be helpful for 11th boards also. This will also be helpful for 11th boards also. Okay, this is state executive and this is state legislature. Okay, now in India, between union government and state government, okay, we separate their powers by a principle called as division of power. We separate their powers by a principle called as division of power. Okay, so by this division of power, what are we doing? We are assigning power to central government and we are assigning power to state government. We are saying that state government, you have power in these areas and you are supreme in these areas, and no one will interfere into a decision which are taken in these areas. And similarly, some areas are given to central government. Okay, so we are dividing power between central government and state government. That concept is called as division of power. Okay, but if you look at judiciary, okay, at central level we have Supreme Court, below Supreme Court we have High Court, below High Court we have District Court or subordinate courts. Okay, below High Court we have District Court or high subordinate courts. Now if you look at legislature and executive, we have division of power, that is these two are independent of each other. But if you look at judiciary in India is integrated. Okay, judiciary in India is integrated. Unlike other two bodies of legislature and executive, judiciary in India is integrated. That is means below Supreme Court there is High Court, below High Court there is District Court. Okay, that is the meaning of integrated. Okay, we follow hierarchy level of judiciary. And apart from judiciary being independent, we also introduce a new type of principle called as separation of power. Separation of power. Okay, so by having this separation of power, we are ensuring the independence of, okay, we are ensuring the independence of judiciary. Okay, we are ensuring the independence of judiciary will act like a separate organ of the government, both executive as well as legislature. They cannot interfere into the affairs of judiciary. That is the meaning of separation of power. Judiciary is kept separate, okay, so that we can ensure independence to Indian judiciary. Okay, so this is how Indian judiciary is set up. Not just Indian judiciary, this is how our Indian government has been set up. Okay, now as I mentioned before, in India we have Supreme Court. Below Supreme Court we have High Court. Okay, below High Court we have subordinate courts. Now see here, importantly, when we talk about integration, okay, when we talk about integration between these three courts, we will only see a judicial integration. Okay, we will see only a type of integration called as judicial integration. Okay, we will see only judicial integration, meaning that judgment given by Supreme Court, it will be implemented in High Court, and judgment given by High Court, it will be implemented in subordinate courts. That is the meaning of judicial integration. But when you look at administrative integration, when you look at administrative functioning, okay, wait, here I will change the color. When you look at administrative functioning, Supreme Court functions as an independent body, independent administrative body. And okay, this is for this is at central level. Now at state level, High Court, okay, High Court will have separate administrative body. Okay, so when we talk about judiciary, integration will be done only at judicial level. Okay, when we talk about administration, Indian judiciary is not integrated. Supreme Court is separate. Okay, the rules and procedure. What do I mean by administration? Rules and procedure. How Supreme Court operates on a daily basis. All these things are kept independent. Okay, Supreme Court functions as an independent body, but High Court, High Court and subordinate courts, they are within a state. Okay, these will operate as a independent body from Supreme Court. Okay, this is only for administrative functions, but for judicial functions, all these three levels of courts are integrated. Is it clear? Is it clear? If you have any doubts, please ask people. Okay, is it clear? Without understanding this, we cannot move further. Okay, without understanding this, we cannot move further. So please ask your doubts if you have any in the chat section, or if you don't have any, please communicate that also. After that, we will move to Supreme Court. Okay, Rajkumar has said that he is clear. Okay, okay everyone, so we will in today's class we are going to look at Supreme Court. Okay, today's class we are going to look at Supreme Court. In another class we will look at the functioning of High Court as well as subordinate courts. See, Supreme Court in Indian Constitution, it is given in Part 5 of Indian Constitution under Chapter 6. Okay, from Article 124 to Article 147. Okay, it is given from Article 124 to Article 147. Supreme Court is subordinate courts, right? See here, as I mentioned before, Rajkumar, in India, okay, Supreme Court in administrative level, Supreme Court is separate, High Court is separate. Okay, but in administration, even though Supreme Court and High Court are separate, under High Court, okay, subordinate courts, they will come under the administrative jurisdiction of High Court. Subordinate courts, they will come under the administrative jurisdiction of High Court. Now both Supreme Court and High Court, these are called as, okay, these are called as higher judiciary. Both Supreme Court and High Court, these are called as higher judiciary. Any court below the level of High Court is called as subordinate courts. Is it clear? Any court which is below the level of High Court is called as subordinate court. Alright. Now only higher judiciary is given the power of judicial review. Only higher judiciary in India is given the power of judicial review. That's why we are distincting higher judiciary and subordinate courts. Only higher judiciary, that is both Supreme Court and High Court, they only are given the power of judicial review, not subordinate courts. Okay. Anything below High Court is called as subordinate courts. Even district court, they are called as subordinate courts. Is that clear, Rajkumar? Okay. Now in Supreme Court, okay, in Supreme Court we will look at various topics. Okay, we will look at various topics like what is the nature of this government body called as Supreme Court. After that we will look at what are the powers and functions of, okay, functions of Supreme Court. So that's how our class is going to take place. This is our this is the overview of our class. In this class we will look at what is the nature of Supreme Court, and also we will look at what are the powers and functions of Supreme Court. So that's what we are going to look in this class. Okay. Now in nature, okay, in nature of Supreme Court we will look at topics like establishment, constitution of, establishment and constitution of Supreme Court, appointment in Supreme Court, okay, tenure of Supreme Court judges, qualification of Supreme Court judges, qualification of Supreme Court judges, okay, removal of Supreme Court judges, appointment of other judges, okay. So all these things are, okay, all these things we will look in nature of Supreme Court. Now in power and functions of Supreme Court we will look at, okay, what is the procedure of Supreme Court, how what kind of procedure is followed in Supreme Court, and we will look at how independence of Supreme Court is established, and also we will look at various things like jurisdiction, okay. Supreme Court is also called as Court of Appeal. What is the meaning of this Court of Appeal? And also we look at the power of judicial review. Okay, so that's how this is the overview of our today. This is the overview of today's classes. Okay, in nature of Supreme Court we are going to discuss establishment and constitution of Supreme Court. So how our constitution has been established, how Supreme Court has been established according to our constitution, and what is the mode of appointment for Supreme Court judges, tenure of Supreme Court judges, qualification of Supreme Court judges, removal of Supreme Court judges, appointment of other judges. Okay, so this is the nature of Supreme Court. After that we will discuss what are the powers as well as functions given to Supreme Court. Okay, so in powers and functions we will discuss what is the procedure followed by Supreme Court. Of course I will explain, Rajkumar, in Court of Appeal, right, in Court of Appeal as well as Court of Record, I will explain this concept called as contempt of court. Okay, I will explain this concept called as contempt of court. Now, okay, apart from procedure of Supreme Court, we will also discuss independence of Supreme Court, jurisdiction of Supreme Court, Court of Record of Supreme Court will act as Court of Record. So we will look at what is this concept of Court of Record, and also we will look at the power of judicial review which is given to Supreme Court. Okay. Now let's discuss the first concept. Okay, first concept, establishment of establishment of establishment of Supreme Court. Okay, see here now these things. Okay, now the topics that I will be discussing today, it will be much more in depth compared to what we are reading from your Lakshmikant book. Okay, in Lakshmikant book it is not given, it is not discussed in an in-depth manner. Okay, so judiciary is not discussed in an in-depth manner. Only 4 to 5 pages are discussed, especially for Supreme Court, which is hardly ideal. Okay, but in my class I will be discussing in depth. Okay, I'll explain each and every portion in detail which are given in Indian Constitution from Article 124 to Article 147. I will discuss each and every article in detail. Okay, see, in establishment of Supreme Court, according to, okay, according to Article 124, there shall be a Supreme Court. There shall be a Supreme Court. Okay, now this Supreme Court, okay, according to Article 124, there shall be a Supreme Court, and this Supreme Court will have one Chief Justice of India plus 7 judges. Okay, so according to Article 124, there shall be a Supreme Court, and this Supreme Court will have one Chief Justice of India plus 7 judges. Okay, now these 7 judges, right? Now these 7 judges, this provision of 7 judges. Now these 7 judges, the number of judges can be regulated by, can be, of course, Rajkumar, it will be regular. Okay, this number of judges will be regulated by an act of Parliament. Okay, according to Article 124, there shall be Supreme Court, and the Supreme Court will have one Chief Justice of India and 7 other judges. And according to Constitution, the number of judges in Supreme Court can be regulated by an act of Parliament. Okay, now using this provision, recently Parliament passed, okay, Parliament passed Supreme Court number of judges act of 2019. Okay, this act increased the number from 30 plus 1 to 34 plus 1. Okay, this act increased the number of judges from 30 plus 1 to 34 plus 1. Okay, is it clear, everyone? This act, this Supreme Court act, okay, this Supreme Court number of judges act of 2019, it increased the number of Supreme Court judges from 30 plus 1 to 34 plus 1. All right, this is how, okay, this is how a number of Supreme Court judges are established. Okay, according to Article 124, there shall be a Supreme Court, and this Supreme Court will have one Chief Justice of India and 7 other judges. Now this other judges, okay, other Supreme Court judges can be regulated by an act of Parliament. Accordingly, recently Parliament has passed Supreme Court number of judges act 2019. According to this act, okay, previous strength has been increased from 31 to 34. Is it clear? Of course, 30 other judges plus 1 Chief Justice, Divya. 30 other judges plus 1 Chief Justice. Is it clear? 30 other judges plus 1 Chief Justice of India. That's what I said, na. 30 plus 1 means 30 judges plus 1 Chief Justice of India. Sorry for this. This is 33. Okay, I forgot. Okay, this is 33. This is 33 plus 1, not 34 plus 1, 34 including Chief Justice of India. Okay. See here everyone, this is establishment of Supreme Court. Is it clear? Is it clear for you? Is it clear everyone? Establishment of Supreme Court. Okay. Now next topic we will look is appointment. Appointment to Supreme Court. Okay, we will look at appointment to Supreme Court. Okay, now accordingly, here when we talk about appointment in Article 124, they talk about two types of appointments. Okay, they talk about two types of appointments: appointment to Chief Justice of India. Okay, appointment to Chief Justice of India and appointment to other judges. Okay, Article 124 talks about two types of appointments. Okay, appointment to Chief Justice of India and then appointment to other judges. Okay, now Chief Justice of India, okay, he is appointed by Chief Justice of India is appointed by President after consultation according to Constitution. Okay, this is according to Constitution. President appoints Chief Justice of India after consultation with such judges of Supreme Court and High Court. Okay, after consulting with some judges from Supreme Court and High Court, President will appoint Chief Justice of India. Is it clear? President upon consultation with such judges of Supreme Court and High Court, he will appoint Chief Justice of India. Now I will explain later. Okay, what is the word of this meaning consultation? Okay, now when it comes to other judges, President appoints other judges on consultation with Chief Justice of India and other judges of Supreme Court and High Court. Okay, President appoints other judges to Supreme Court on consultation with Chief Justice of India and other judges of Supreme Court and High Court. Is it clear? Now this word consultation has proved very controversial. Okay, this word consultation has proved very controversial. Okay, Constitution does not define whether during this consultation process whether the opinion given by this judges of Supreme Court and High Court is binding or not. Constitution is does not have a provision regarding that. Okay, it is very vague on this consultation process. Okay, so that's why because of this vague definition of consultation process, during 1970s a lot of controversy arise because of this vague definition of the word consultation. Can I understand? Can you understand what I am trying to say? The word consultation is very vague, is not defined in the Constitution. Is it clear? If judges or Supreme Court Chief Justice of India is giving his opinion during this consultation process, Constitution does not specify whether this consultation is binding or not. Okay, since Constitution did not specify whether this consultation is binding or not. Okay, so if you look at appointments to Chief Justice of India from 1950 to 1973. If you look at the appointments from 1950 to 1953, okay, the practice is to appoint senior most judge. Senior most judge of Supreme Court as Chief Justice of India. Okay, the prevailing practice from 1950 to 1973 was to appoint senior most judge of Supreme Court as Chief Justice of India. But in 1973, now in 1973, who was PM? Indira Gandhi. Okay, now most of the abuse of Constitution took place during Indira Gandhi period. Okay, she handled Indian Constitution in a very draconian manner. She abused the Constitution like anything. Okay, people talking about abusing of Constitution today don't have any idea about how Indira Gandhi abused constitution back then. Okay, now Indira Gandhi abused not only emergency provision and other provision, she also abused this appointment of judges also. Since this word consultation is very vague, since this word consultation is very vague, during this time, okay, A.N. Ray was appointed as Chief Justice of India, ignoring 3 other judges who were senior to A.N. Ray. Okay, before A.N. Ray, there were 3 other senior judges waiting to be appointed as Chief Justice of India. Okay, but this was omitted by President at that time, and A.N. Ray was appointed as Chief Justice of India. Now, similarly, in 1977 also, M.U. Beg was appointed as Chief Justice of India, ignoring seniority. Okay, even with the 3 other judges before M.U. Beg, he was appointed as Chief Justice of India. Okay, now this consultation, right? So this shows that until 1980s, central government enjoyed discretion in appointment of judges. Okay, until 1980s, central government enjoyed discretion in appointment of judges. What is the meaning of enjoying discretion? Central government will appoint any member they like as long as they are qualified to Supreme Court Judge of India. Okay, they will appoint whatever person they like. Even CJI as well as Supreme Court judges and High Court judges, they will appoint whichever person they like. Okay, because they enjoy considerable amount of discretion. Because why? The word consultation was not clearly defined in the Constitution. Okay, the word consultation was not clearly defined in the Constitution. Because of that, right until 1980s, central government enjoyed considerable discretion in appointment of judges. Okay, now this discretion was curtailed during second judge's cases. This discretion was curtailed during second judge's case in Supreme Court. Okay, now as I mentioned before, since central government enjoyed considerable amount of discretion, okay, and the word consultation is not clearly defined in the Constitution, there was a lot of controversy arising because of that. Central government started appointing judges who were favorable to their government in Supreme Court. All these controversy arise because of that. Now, because of that issue, Supreme Court intervened in this process. Supreme Court intervened into the process of appointment of judges. Okay. Now, what did Constitution say? Chief Justice will provide consultation, right? Chief Justice and other judges will provide consultation to President for appointment of judges, right? That's what Constitution says. Now, this word consultation has been interpreted in 3 different Supreme Court cases. This word consultation has been interpreted in 3 different Supreme Court cases. The first one is the first judge's cases. First one is the first judge's case. Now, according to this first judge's case, the word consultation means only exchange of views. The word consultation means merely exchange of views. So, Chief Justice of India and other judges of Supreme Court, they will merely give their views on appointment, and their views is not binding on President of India. Now, but in second judge's cases, this consultation means concurrence. This consultation meant that concurrence of Chief Justice of India and other judges of Supreme Court. Okay, what is the meaning of concurrence? President has to get the approval of Chief Justice and other judges to appoint judges to Supreme Court and High Court. That's the meaning of the word concurrence. Yeah, President has to get the approval from Chief Justice of India and other judges of Supreme Court. That is the meaning of the word concurrence. But even providing some sort of clarity for this word consultation, even then the concurrence, the word concurrence, what kind of concurrence? Okay, this should this concurrence be given only by Chief Justice of India or by all the other judges, or this concurrence will be given by means of majority or absolute majority? All these types of questions lingered after this case. Okay, what type of concurrence should we give? How many judges should give their concurrence? All this was unanswered in this second judges cases. Now, to clarify, okay, now to clarify the judgment of second judges cases, Supreme Court, okay, Supreme Court, wait here. Sorry for that. Supreme Court in third judges case, Supreme Court in third judges case, okay, it sought to clarify, it sought to clarify this concurrence process which was said in second judges cases. So according to third judges cases, okay, this third judges cases, concurrence means, okay, this, the word concurrence means consultation with plurality of judges. Okay, the word consultation means, so the word concurrence means consultation with plurality of judges. Okay, the word concurrence means consultation with plurality of judges. So accordingly, since the word concurrence meant that consultation with plurality of judges, okay, so according to the three judges cases, this plurality of judges will be a 4-member body called as collegium. Okay, this plurality of judges will be a 4-member body called as collegium. Okay, now in this 4-member body, okay, this collegium, in this collegium, if two members adverse opinion, Chief Justice of India should not send the recommendation to government. Okay, in this, within this 4-member body, even if two judges are giving their adverse opinion, if two judges are not satisfied with this appointment, if they feel that he is not done well enough, he is not qualified enough to become Supreme Court judge, then Chief Justice of India will not send this recommendation to President. Okay, and also if Chief Justice of India gives recommendation, Chief Justice of India gives recommendation without complying, that this, it will be appointed by Chief Justice of India, Divya. I'll explain later. Okay, how collegium is appointed, all these things I will explain later. Now see here, CGI, if he gives recommendation without complying norms and requirement, okay, norms and requirements of collegium, okay, the recommendation is not binding. The recommendation is not binding. So if Chief Justice of India, if he is sending a recommendation without complying the norms and requirements of collegium, okay, then the recommendation is not binding. Judges, what is the meaning of, what is judges star? What is the meaning of the term, Kumar? See here, Okay, now I've explained these three different types of court cases which delved into the appointment of Supreme Court judges. Okay, the first one is first judges cases, second judges cases, third judges case. Okay, now first judges case meant that the process of consultation with Chief Justice of India meant only exchange of views. Okay, now in second judges case, the word concurrence meant that Chief Justice of India has to agree with that particular decision. Only then president will be able to appoint. Okay, now in third judge's case, the word concurrence was expanded considerably. Now concurrence mean that consultation with plurality of judges. Now this plurality of judges will be established as a body called as collegium, a four-member body called as collegium. Now this collegium, in this collegium, even if two members give their adverse opinion, Chief Justice should not send the recommendation to government, and Chief Justice, if he gives the recommendation without consulting the collegium, then the recommendation is not binding on President of India. Okay, okay everyone, is it clear? Is it clear so far? If you have any doubts, please ask. Is it clear? Now give me a moment here, I will change the plurality. Means what? Plural means what? More than one person, two or more members. That is the meaning of plurality. That is the meaning of plurality, Nitya Singotayan. Okay, plurality means more than two persons. Okay, give me a moment here, I will change the chairs. Is it clear, Nitya, for you? Okay. Okay, everyone. Now let's move on to the next part. We will discuss this collegium system. Now we will discuss this collegium system. Okay. Now keep in mind. Okay. Now keep in mind this collegium system is not mentioned in this collegium system is not mentioned in either Constitution or subsequent Constitution Amendment Act. Okay, this word collegium for appointment of judges to Supreme Court is not mentioned either in Constitution or subsequent Constitution Amendment Acts. Okay. Now, see here in this collegium system, what happens is that, okay, collegium system, right? So according to this collegium system, this collegium, okay, they will recommend via Chief Justice of India, they will recommend members, they will recommend judges via Chief Justice of India to President. Meaning, what is the meaning of President? President is who? Okay, who will give approval for this recommendation? That is central government, right? Okay, collegium, they will send their recommendations to central government via Chief Justice of India. See here, now who will prescribe names for collegium's consideration? Who will prescribe names for collegium's consideration? Okay, Chief Justice collegium, they will recommend some name. For example, if there is two vacancies that are there in Supreme Court, two names have to be recommended for appointment to president. Okay, so who will provide this initial list? Okay, within that list they will scrutinize various members. Out of these members only they can appoint judges to Supreme Court, right? So the original names, okay, the names to collegium system will be given by central government. Okay, central government, they will prepare a list of names that should be appointed as judges of Supreme Court or High Court. Now they will give these names to collegium. Okay, now this collegium, after extensive consultation between among themselves, they will scrutinize all these candidates whether they are fit to become Supreme Court judges, and they will look at their past history, past cases history, all these things. So based on their consultative process, they will recommend names to President via Chief Justice of India. Is it clear? So that's how collegium operates. But if you look at here, this collegium is not a constitutional body. It is not a constitutional body or statutory body. Okay, this collegium system is not a constitution body or a statutory body. What is the meaning of it is not a constitutional body or a statutory body? What is the meaning of that? Meaning that this collegium has no transparency. This collegium has no transparency. Since the procedure, okay, what kind of procedure is being followed in collegium system, how the candidates are being verified, how they are being selected, how they are being rejected, all this process is not clearly defined either in constitution or in parliamentary law. Since it is not clearly defined, there is no transparency. There is no transparency in the appointment of judges in collegium system. Okay, so because there is no transparency, what happened is that the representation in Supreme Court is abysmal compared to other two organs. Representation in Supreme Court is abysmal compared to other two organs. What is the meaning of representation? If you look at Supreme Court, almost 80% of judges in Supreme Court come from upper caste background. Okay, the composition of OBCs and SC and ST population is very, very abysmal in Supreme Court. Not only representation in Supreme Court is abysmal, the quality of judges appointed is decreasing year on year. The quality of judges appointed is decreasing year on year. Okay, so that's a problem with collegium system. Okay, that's a problem with the collegium system. Since it's neither constitutional body nor a statutory body, there is no transparency. Why? Because their rules are not defined either in constitution or statutory body. Okay, so because of that, there has been a lot of problems arising because of collegium system. There is because of that, there is no representation in Supreme Court adequately for all sections of Indian society, and the quality of judges being appointed in Supreme Court and High Court is decreasing year on year. Okay, and also the rules, okay, the committee, all these things is not very clear. Okay, what kind of rules is being followed by collegium system? It's not clearly defined. Okay, so to solve this problem, central government via 99th Constitution Amendment Act, replaced collegium with a new body called as National Judicial Appointments Commission. Okay, according to this 99th Constitution Amendment Act, this body of collegium is replaced by a body called as National Judicial Appointments Commission. Okay, now this National Judicial Appointments Commission, it will be a constitutional body. Okay, the procedure will be clearly defined in the constitution. Okay, so all these provisions will be followed by letter of law. Okay, if a judge is being appointed to Supreme Court, this appointments committee, National Judicial Appointments Committee, they will make sure that all the rules and procedures mentioned in the constitution are being followed. Okay, but this provision of National Judicial Appointments Committee was declared unconstitutional. Okay, it was declared unconstitutional. It was declared as unconstitutional by Supreme Court. Okay, now this National Judicial Appointment Commission. Okay, this 99th Constitution Amendment Act was declared as unconstitutional by Supreme Court by the power of judicial review, by using the power of judicial review. Is it clear? See here, this shows how much power Supreme Court is currently enjoying in Indian Constitution setup. Okay, this shows how much power Supreme Court enjoys in our constitutional setup. Okay, now if you look at Supreme Court, judges, okay, judges are appointed to Supreme Court by Supreme Court, and how, okay, so what happens here? The persons who are coming into Supreme Court, they are determined by Supreme Court. There is no checks and balances for Supreme Court, and any attempt to regulate the functions of Supreme Court by legislature will be struck down by Supreme Court by using the power of judicial review. Am I being making my point clear? Supreme Court, who is appointing judges to Supreme Court? By a body called as collegium, and collegium is a body made up of Supreme Court judges. Okay, so Supreme Court itself is making appointments to Supreme Court, and there is no regulation for that process. Okay, and any attempt by Parliament to regulate that process will be struck down by Supreme Court, citing ultra vires of Indian Constitution. That is, they will declare this Constitution Amendment as unconstitutional. So this shows that how much power is currently being enjoyed by Supreme Court. Okay, see here, if you look at USA, most of the provisions in Supreme Court have been borrowed from USA. In USA, what happens? Constitution is there. From Constitution, all the powers of bodies, executive, legislature, and judiciary, all these three bodies will derive the power from Constitution. Okay, and these powers are the powers of these bodies are separated from each other by a concept called as separation of power. Okay, and if you look at why this separation of power was there, why this separation of power concept was introduced, why? Because to introduce a concept called as checks and balances. To introduce a concept called as checks and balances. Why is this very important? Okay, if judiciary is becoming all too powerful, legislature will act in and they will try to curb the power of judiciary. And if legislature is acting too powerful, judiciary will come in and they will try to curtail the powers of legislature. And similarly, if executive is doing acting very unilaterally and they are becoming more powerful, legislature will come in and they will try to curtail the power of executive, and similarly judiciary also will try to curtail the power of executive. Okay, but even in USA, to ensure this checks and balances principle, appointments to judiciary, okay, appointments to judiciary is made by executive. Okay, okay, the appointments to judiciary, okay, the names will be recommended by executive, that is, president will appoint judges to judiciary. Why? Because there should be a principle called as checks and balances. Is it clear? Now to curtail the power of judiciary, the power of appointment as well as removal will be given to executive and legislature. Only executive can appoint judges to judiciary, and legislature will remove judges. Legislature will remove judges from judiciary. This is the concept called as power of checks and balances. But in India, there is no such thing called as checks and balances for judiciary. Judiciary in India has become all too powerful. It has become very powerful. Okay, this is one. Now collegium is valid, Rajkumar. Now collegium is valid because that 99th Constitution Amendment that has been declared as unconstitutional, right? So collegium is right now valid. Okay. So any doubt, people? Any doubt so far? Okay. If you have any doubts, please ask. After that, I have to move to the next part. I have to move to the next part of this topic. Please mention whether you have understood or not. Now, give me a moment here. Of course, in see here, Rajkumar, see here. This concept called as supremacy, right? See, in government is a body which has three bodies. Okay, government is any body which has three functions: executive, legislative, and judicial functions. Government is any body which has these three powers: executive, legislature, and judicial powers. Now, in olden days, all these three powers, all these three powers, executive, legislature, and judiciary, it was enjoyed by a person called as king. Okay, so this theory is called as doctrine of divine rights. This theory is called as doctrine of divine rights. Now gradually, okay, now gradually, all these powers from king in UK was taken away by a body called as parliament. Okay, now all these powers were taken by a body called as parliament. So in UK, right from 1850 onwards, parliament exercised executive, legislature, and judiciary. Okay, so now this, since all these powers are derived from parliament, this is called as doctrine of, this type of government is called as doctrine of parliamentary supremacy. This type of government is called as doctrine of parliamentary supremacy. Okay, now I'll explain your doubt, Nitya, later on. See here. Now in USA, they did not follow this doctrine of parliamentary supremacy because they thought that even though the parliament is a democratic body, still parliament is all too powerful. There is no checks and balances imposed on parliament. So what they did was that they separated all these organs into different bodies. They separated all these functions into different bodies. So executive function was given to president, legislative function was given to a body called as Congress, and judicial function was given to a body called as Supreme Court. Is it clear? Now, so USA, when they adopted constitution, they felt that even though parliament is somewhat an improvement on monarchical form of government, still it is very powerful. So they separated all these three individual organs into separate bodies. Executive is given to president, legislature is given to Congress, and judiciary is given to Supreme Court. Now all these organs derived their power from constitution. All these organs derived their power from constitution. Now this type of government is called as doctrine of constitutional supremacy. This type of government is called as doctrine of constitutional supremacy. Why? Because the powers of all these three bodies are derived from the constitution. Now similarly, the power of president, the power of legislature, the power of executive, the power of judiciary, all these powers are derived from the constitution. So that's why in India we follow doctrine of constitutional supremacy. That's why constitution is supreme in India. Of course, Nitya Sengotian, that's the meaning of having parliamentary form of government, right? In India, union executive will also be a member of union legislature. Only an MP can become minister. If a non-MP is becoming minister, he has to become an MP either in Lok Sabha or Rajya Sabha within 6 months. Is it clear, Nitya? That's the meaning of parliamentary form of government. Okay, we follow a mixture of parliamentary form of government and doctrine of constitutional supremacy. Okay, in this concept itself, we have incorporated parliamentary form of government. That's what I mentioned in the first class itself, right? In the first itself, I've given the flow chart, right? See here, this is union executive and this is union legislature. Okay, and all these bodies derive their power from constitution. Is it clear, everyone? Nitya, is it clear to you? Only if you are saying clear, I will move on to the next part, next topic. Nitya Sengotian, is it clear to you? Okay. Now so far we have discussed this concept called as appointment to Supreme Court judges. Now we will discuss what are the qualifications for Supreme Court judges. What are the qualification of What is the qualification of Supreme Court judge? That we will discuss. See here, for a person to become Supreme Court judge, he must to be a citizen of India. He must be a citizen of India. He must be a judge of High Court or High Courts. Okay, High Courts for 5 years. He must be a judge of High Court or High Courts for 5 years. He must be an advocate of High Court or High Courts for 10 years. He must be an advocate for High Court or High Courts for 10 years, or he must be a distinguished jurist. He must be a distinguished jurist in the opinion of president. In the opinion of president, he must be a distinguished jurist in the opinion of president. Okay, and importantly, see, importantly, Constitution does not prescribe minimum age of Supreme Court judge. Constitution does not prescribe the minimum age for Supreme Court judge. No, I am not aware of that, Rajkumar Yadav. Sorry for that. I am not aware of any particular advocate of High Court or become Supreme Court judge. I am not aware of that. But according to Article 124, okay, now all these qualifications have been given in Article 124. All these qualifications required to become Supreme Court judge is given in Article 124. Okay. Now I am not sure which advocate of High Court has been appointed as Supreme Court judge. I am not aware of that. Sorry for that. Now, importantly, Constitution does not prescribe the minimum age to become Supreme Court judge. Okay. Now the next provision is oath and affirmation. Oath and affirmation. See here, according to Article 124, according to Article 124, a person before entering as a judge of Supreme Court, before he enters as a judge of Supreme Court, okay, before this process he has to give oath or affirmation for Supreme Court judge given in 3rd schedule. Is it clear? A person before entering as a judge of Supreme Court, he has to give oath or affirmation given for Supreme Court judge, which is given in 3rd schedule. Now, if you look at the oath or affirmation given by Supreme Court judge, the oath will be given as one, okay, to bear true faith, allegiance to Constitution of India, to bear true faith and allegiance to Constitution of India, to uphold the sovereignty and integrity of India, to uphold the sovereignty and integrity of, third one, to duly and faithfully unto my best of ability perform the duty of office without fear or favors or ill wills. Okay, and lastly, he has to give an oath to uphold constitution and the laws. He has to give an oath to uphold the constitution and laws. Okay, so this is the oath that is given by Supreme Court judges. Okay, now this oath is mentioned in third schedule of Indian Constitution. Okay, the first one is to bear true faith and allegiance to Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to my best of ability perform the duty of office without fear or favors or ill wills, and to uphold constitution and laws of the country. Okay, so this is tenure of Supreme Court judges. So this is the oath and affirmation of Supreme Court judges. Next topic that we will discuss is tenure of Supreme Court judges. The next time we will discuss is tenure of Supreme Court judges. Okay, see, according to Article 124, okay, it has not fixed the tenure of Supreme Court judges. See, Article 124, it did not fix the tenure of Supreme Court judges. It did not prescribe that a Supreme Court judge will act as judge only for 6 years or 10 years. It has not fixed tenure of Supreme Court judges, but the tenure of Supreme Court judge is subject to some conditions. Okay, first thing is, according to Article 124, Supreme Court Constitution has not fixed the tenure of Supreme Court judges, but the tenure of Supreme Court judges is subject to some conditions according to Constitution of India. Now, what are these conditions? Prescribed by Constitution of India in Supreme Court judges. Okay, now according to Constitution of India, the conditions that has to be met during this tenure is that he holds the office until the age of 65. Okay, a Supreme Court judge will hold the office there is no need per se, Nitya, there is no need to remember oath and affirmation and all, but to teach in depth. Okay, only when I am teaching every part of our constitution, I can make sure that you are learning correctly. Okay, only when I am teaching all these things, then only I can make sure that you are learning correctly. Okay, so that's why I am also listing the oath and affirmation, but it is not important from examination point of view. Now he holds the office until the age of 65. That's the first condition. The next one is he can resign. From his office by writing to President. Okay, a Supreme Court judge can resign from his office by writing to President, and also he can be removed by President on recommendation of President on recommendation of Parliament. Okay, so these are the conditions during the tenure. The first one is that Supreme Court judge will hold the office until the age of 65. He can resign from his office by writing to President, and he can be removed by President of India on recommendation of Parliament. Okay, so next topic that we are going to look today is the third condition. Okay, removal of judges. Removal of judges. Okay, so before going into this topic, now please people, if you have any doubts, please ask right now. If you have any doubts, ask right now. People, if you have any doubts, ask right now, and I will try to answer those. No. Okay. Okay, everyone. Since you have not given your okay, see here. Now let's move on to the next part. Okay, now let's move on to the next part. Removal of judges. Okay, see, according to Article 124 Clause 4, according to Article 124 Clause 4, a judge of Supreme Court can be removed on two grounds. Okay, a judge of Supreme Court can be removed on two grounds. Okay, those grounds are proved misbehavior, proven misbehavior, and then incapacity. Okay, proven incapacity. These are the two grounds based on which a Supreme Court judge can be removed. Okay, now the procedure for removal is, okay, now the procedure for removal according to Article 124 is President by issuing an order. Okay, President by issuing an order will can remove judge of Supreme Court. Okay, President by issuing an order can remove the judge of Supreme Court. Okay, now President will issue the order on consultation. Okay, only after the address of Parliament. Okay, only after the address of Parliament. Okay, if Parliament via special address is recommending to President to remove a Supreme Court judge, then only President will issue an order for removal of Supreme Court judges. Okay, now this address in both the houses, in this address of Parliament for removal of Supreme Court judge has to be passed in Parliament by 2/3 of members present and voting plus half the members voting for it. Okay, so the majority required for passing this address is 2/3 of members present and voting, and half the members voting for this address. Now, according to Article 124 Clause 4, this address of Parliament, right? The procedure for address of this Parliament. Okay, now the procedure can be regulated by Parliament. This procedure of address of Parliament can be regulated by Parliament. Okay, how, in what manner this address is passed in the Parliament, and how this motion for this address of Parliament is admitted into either Lok Sabha or Rajya Sabha. So all this procedure is regulated by the Act of Parliament. Okay, it is regulated by Parliament by law. Okay, now using this provision, okay, Parliament has passed an act called as Judges Enquiry Act of 1968. Judges Enquiry Act of 1968. So using this provision given in Article 124, Judges Enquiry Act of 1968 was passed by the Parliament. So according to this act, the procedure for removal of a judge in judge of Supreme Court is that a motion, if it is in Lok Sabha, that motion has to be signed by 100 members. If it is in Rajya Sabha, okay, if it is in Rajya Sabha, this motion has to be signed by 50 members. Okay, this motion, it has to be signed by 100 members in Lok Sabha and 50 members in Rajya Sabha. This motion has to be submitted to either Speaker or Chairman. Is it clear? This motion is submitted either to Speaker or Chairman. Now, Speaker or Chairman, they may accept this motion, or they can refuse this motion. Okay, they may accept this motion or they can refuse this motion. All right, they may accept this motion or they may refuse this motion. So it's at the discretion of Speaker whether to admit this motion or not. Okay, now once Speaker has accepted this motion, okay, the Speaker or Chairman will form a 3-member committee. Okay, once this motion has been admitted by either Speaker or Chairman will form a 3-member committee. He will form a 3-member committee. Now, in this 3-member committee, there will be members like Chief Justice. If Chief Justice is being removed, a Judge of Supreme Court, a Chief Justice of High Court, and a distinguished jurist. Okay. Now this 3-member committee. Okay. Now this 3-member committee, it will investigate the charges. And it will also inquire into the charges. Now during this investigative process as well as inquiry process, the accused Supreme Court judge, he will appear before this committee and he has the right to defend himself. Okay, before this committee, the accused has the right to defend himself. Okay, now this 3-member committee, after their investigation, they will submit their report. Now this report, it will find the judge either guilty or not guilty. Okay, it will find him either guilty or not guilty. If the Judge of Supreme Court is found to be guilty of said offences, what will happen is that, okay, if this committee finds him guilty, this motion will be passed via special majority. This motion has to be passed via special majority in first house. If this motion has to be passed via special majority in first house, after it has passed in first house, this motion will go to second house. Even in second house, this motion has to approved by special majority. Okay, this even in second house, this motion has to be approved by special majority, and this motion will go for president. Okay, once this motion has gone to president will issue an order. For removal of Supreme Court judge. Okay, President will issue an order for removal of Supreme Court judge. Okay, so this is the process of removal of Supreme Court judge, everyone. Okay, so if you have any doubts, please ask right now. Please ask in the chat section, and I will try to answer those doubts. If you're not asking doubts, I will move on to the next part. If you're not asking doubts, I will move on to the next parts. Next parts like salaries and allowances, appointment of other judges, all these things we will discuss. Okay. So please ask right now. After that, I will move on to the next part. Okay, since no one is asking doubts, I will move on to the next part. Okay. Since no one is asking, I will move on to the next part. So far we have discussed only one article. Okay, so far in this 1.5 hour class, we have discussed only one article. That is Article 124. It is a very lengthy article. There are around 7 clauses. We have discussed so far 6 clauses. We have discussed 6 clauses. Now we will discuss the last clause. Okay, now we will discuss the last clause. According to Article 124 Clause 7. According to Article 124 Clause 7, no person who holds the office of Supreme Court, the office of Judge of Supreme Court, shall plead or act in any court or before any authority within territory of India. Is it clear? No person who holds the office of Judge of Supreme Court shall plead or act in any court or before any authority within territory of India. So, which means that he cannot act as lawyer for any other person. Okay, since he is the Judge of Supreme Court, he cannot act as he cannot act as lawyer for any other court in within territory of India. That's what Article 124 Clause 7 says. Okay. Now the next provision is salaries and allowances of Supreme Court judges. Okay, salaries and allowances of Supreme Court judges. Okay, so now the salaries and allowances are mentioned in Article 125. Okay, now so far we have discussed Article 124. Now the salaries and allowances it is given in Article 125. Okay, according to Article 125, salaries, allowances, privileges, leave provisions, pension of Supreme Court judges. Okay, the salaries, allowances, privileges, leave, pension of Supreme Court judges, they will be determined by law of Parliament from time to time. Okay, all these things like their salaries and allowances, it will be determined by law of Parliament from time to time. Now, crucially, okay, this is clause 1 in Article 125. Now, according to clause 2, these salaries and allowances provisions, they cannot be varied to the disadvantage okay, it cannot be varied to the disadvantage of uh, judges except during financial emergency, except during financial emergency. Is it clear? Except during financial emergency, once a Supreme Court judge has been appointed, his salaries as well as allowances, it cannot be decreased. Okay, if he's enjoyed a certain amount of privileges as well as allowances, he will continue to enjoy those privileges as well as allowances right until he retires. Okay, it cannot be reduced, and except during financial emergency. Okay. Now let's so far we have discussed the nature of Supreme Court judges. Now all these provisions we have discussed, right? These are for normal judges. Okay, these are for normal judges. Okay. Now next provision that we will discuss today is appointment of acting Chief Justice of India. Appointment of acting Chief Justice of India. Okay. So according to Article 126, President, okay, President can appoint a judge of Supreme Court. President can appoint judge of Supreme Court as an acting Chief Justice of India if the current Chief Justice of India is vacant. Okay, if he is vacant or if he is temporarily absent or if he is unable to perform. All right. So when all these three things are there, when the current Chief Justice of India is being vacant, or if he is temporarily absent, or if he is unable to perform, President will appoint a judge of Supreme Court as acting Chief Justice of India according to Article 126. Okay. Now this is Article 126. Now our next one is appointment of ad hoc judges. Appointment of ad hoc judges. Okay, so according to Article 127, according to Article 127, if there is a lack of quorum, what is the meaning of lack of quorum? The number of minimum judges required for a bench. Okay, if there is a lack of quorum, if there is no minimum amount of judges in a present bench, Chief Justice of India can approve. He can approve a judge of High Court. To function as ad hoc judge of Supreme Court. Okay, if there is a lack of quorum, if there is no quorum in the Supreme Court, Chief Justice of India can approve the current judge of High Court to function as ad hoc judge of Supreme Court. Okay, for a temporary period. Okay, this ad hoc judge will be for only a temporary period. Okay, he will discharge his function as ad hoc judge only for a temporary period. Okay, and he will be appointed. These ad hoc judges will be appointed on consultation with Chief Justice of High Court. Okay, Chief Justice of High Court, and then these ad hoc judges will enjoy all privileges of Supreme Court judge. They will enjoy all the privileges of Supreme Court judges. Okay, this is the condition, and importantly, this judge of Supreme High Court, if he is to be appointed as ad hoc judge, he should be qualified to become Supreme Court judge in the first place. Only then he will be appointed as ad hoc judge. Okay, so according to Article 127, if there is a lack of quorum in Supreme Court, what is the meaning of lack of quorum? The minimum number of judges required for a sitting in a bench is 3. If there is no if there are no 3 members in a particular bench, what will happen? A Chief Justice of India, he can approve a judge of High Court to be acting as an ad hoc judge of Supreme Court. Now this ad hoc judge will be only for a temporary period, and he will be appointed only under the consultation of High Court, and this ad hoc judge will enjoy all the privileges and allowances given to Supreme Court judges. And if this judge of High Court is to be appointed as ad hoc judge of Supreme Court, this judge of High Court should be qualified enough to become Supreme Court judge. Okay, so that is Article 127. The next one is appointment of retired judges. Appointment of retired judges. Okay, the appointment of retired judges. See here, according to Article 128, according to Article 128, Chief Justice of India, okay, with previous sanction of President, he can request, okay, Chief Justice of India, he can request, okay, a retired Supreme Court judge or a retired High Court judge, okay, to act as an ad hoc judge, okay, to act as an ad hoc judge. All right, now this retired and retired High Court judges should be qualified for Supreme Court judge. They should be qualified to become Supreme Court judge. Okay, now this ad hoc judge is only for temporary period, and he will also enjoy all privileges. He will also enjoy all privileges of Supreme Court judge. Is it clear? He will enjoy all the privileges of Supreme Court judge. That's Article 128. Okay. Now the next one is the seat of Supreme Court. The next provision is seat of Supreme Court. The next provision is seat of Supreme Court. See, according to Article 130, Supreme Court will sit in Delhi. Supreme Court will sit in Delhi or other places. Okay, Okay, now these other places will be determined by Chief Justice of India and approved by President of India. Okay, if Supreme Court wants to form a bench, Supreme Court can form a bench in either Bangalore or Chennai or Kolkata, and these other places, they will be determined by Chief Justice of India and they will be approved by President of India. Okay, so that is seat of Supreme Court. Okay, now the next one is procedure of Supreme Court. Now, according to Article 145, the Supreme Court, okay, the Supreme Court can, with the approval of President, can make rules, okay, for regulating general practice and procedure of court. Of the court. Okay, Supreme Court, according to Article 145, Supreme Court can, with the approval of President of India, they can make rules for regulating general practice and procedure of the court. Okay, Now we have discussed the procedure of the court. Now we will also discuss the independence of Supreme Court. Okay, so how constitution, we will discuss how our constitution ensures the independence of Supreme Court. Okay, now our constitution ensures the independence of Supreme Court by prescribing the mode of appointment. Okay, by prescribing the mode of appointment. Okay, and it also provide security of tenure for Supreme Court. Okay, now how are they providing this security of tenure? Okay, by providing having fixed services, and also their allowances are, their salaries and allowances are charged on Consolidated Fund of India. Okay, and then the conduct of judges cannot be discussed in, cannot be discussed in Parliament. Okay, the conduct of judges cannot be discussed in Parliament, and also there is a ban on practice after retirement. There is a ban on practice after retirement. Okay, and then there is a power of contempt given to Supreme Court. Okay, and then Supreme Court is given the freedom to appoint its own staff, to appoint its staff. Okay, and then the jurisdiction of Supreme Court cannot be, the jurisdiction of Supreme Court cannot be curtailed. This is given in Article 138. It can only be extended, it cannot be curtailed. And also we can ensure that next one is judiciary is separated from executive. Okay, judiciary is separated from executive. So these are the ways. Okay, these are the ways the constitution has ensured the independence of Supreme Court. Okay, the first one is mode of appointment, the next one is security of tenure, the conduct of judges cannot be discussed in the Parliament. Okay, and there is a ban on practice after retirement. Okay, and then there is power of contempt given to Supreme Court, the freedom to appoint their own staff, and then the jurisdiction of Supreme Court cannot be curtailed by the Parliament according to Article 138, and the separation from executive. Okay, so all these are provisions which are given to ensure the independence of Supreme Court. All these are given to ensure the independence of Supreme Court. Okay, now if you look at the next provision, now we have successfully discussed the, what to say, the nature of Supreme Court. Okay, how Supreme Court has been set up in Indian constitution. All these things we have discussed so far. Okay, all these things we have discussed so far. Now the next thing we have to discuss is power of Supreme Court. Power of Supreme Court. Now next thing we have to discuss is power of Supreme Court. Now in power of Supreme Court we will discuss the jurisdiction of Supreme Court. We will discuss the jurisdiction of Supreme Court, and we will discuss the power of Supreme Court called as court of record. Okay, court of record, and then we will also discuss the power of judicial review of Supreme Court. Okay, so in jurisdiction we will discuss various things like the power of original jurisdiction given to Supreme Court. Okay, appellate jurisdiction. Okay, advisory jurisdiction. Okay, so all these things we will discuss in this video right now. Okay, now the first jurisdiction we will discuss is, and then the first jurisdiction we will discuss is original jurisdiction of Supreme Court. Original jurisdiction of Supreme Court. Okay, So now before moving further, I will give you 2 to 3 minutes to ask your doubts, people. If you have any doubts, okay, please ask those doubts, or else I will move on to the next part. Okay, please ask your doubts, people. Okay. Okay, I have discussed everything. Okay, I have discussed right now. So yes, what I taught in my previous class, so that only you can understand what I'm going to teach today. So here in India, we follow a integrated system of judiciary where we have Supreme Court. Below Supreme Court, we have High Court. Below High Court, we have subordinate courts. Okay, so in India, we have Supreme Court at the highest level. We have High Court, and then below High Court, we have subordinate courts. Now, both Supreme Court and High Court, these are termed as higher judiciary. These are termed as higher judiciary, and any court below the level of high court, it will be termed as subordinate courts. Any court below the level of high court, it will be termed as subordinate courts. Okay, now see here, in our last class we looked at Supreme Court. Okay, in our last class we looked at Supreme Court. In Supreme Court, as I mentioned in last class, okay, we will discuss Supreme Court. We will discuss everything. We will discuss Supreme Court. Okay, we will discuss Supreme Court in two parts. We will discuss Supreme Court in two parts. One is we will discuss the nature of Supreme Court, and then we will discuss the powers and functions of Supreme Court. The powers and functions of Supreme Court. Okay, in our last class we took we studied almost 2 hours for to examine what is the nature of Supreme Court. Okay, in almost for 2 hours I took a class where I examine what is the nature of Supreme Court, like how Supreme Court is established. Okay, and then what is the tenure of Supreme Court judges, how their appointment. Okay, and then their qualification. Okay, their removal, their oath, and then their and then we discussed appointment of other judges. Appointment of other judges. Okay, so these are the things that we discussed in our previous class. Okay, establish how the Supreme Court is established, what is the tenure of Supreme Court, how they are appointed, and what is the qualification required, how judges of Supreme Court are removed, and the oath and affirmation required for a person to become Supreme Court judge, and appointment of other judges. So these are the things that we discussed in our previous class. Okay, now in this class we are going to discuss the powers and functions of Supreme Court. Okay, the powers and functions of Supreme Court. Now if we discuss the powers and functions of Supreme Court, okay, the and powers and functions of, I don't know what is happening here. The powers and functions of Supreme Court. Okay, in within the powers and functions of Supreme Court, we will be discussing 4 things. Okay, we will be discussing 4 things. One is the procedure of Supreme Court, okay, and then the jurisdiction of Supreme Court, Supreme Court as a court of record, and then lastly we will discuss the power of judicial review. Okay, so these are the things that we are going to discuss here in power and functions. Of course, Vijayalakshmi, I am teaching in English only. I am not teaching in Hindi. Okay, I will be teaching in English only. So these are the things that we will be discussing Supreme Court. Okay, the powers and functions of Supreme Court, procedure of Supreme Court, jurisdiction of Supreme Court as a court of record, and the power of judicial review of Supreme Court. Okay. See here, the first thing is the procedure of Supreme Court. The first thing we are going to discuss is Procedure of Supreme. What is the meaning of procedure of Supreme Court? See, procedure concerns with day-to-day administration of Supreme Court. Okay, what is the power of Tawari in Supreme Court? What is the power of the individual clerk in that particular Supreme Court office? Okay, Supreme Court, they not only deliver judgments. For maintaining Supreme Court itself, they require an administrative apparatus. Okay, apart from judges, Supreme Court requires administrative apparatus. Okay, so that is called as procedure of Supreme Court. Now, according to Article 145, according to Article 145, okay, Supreme Court can, with the approval of President, okay, they can, what they can do is they can make rules and regulations. They can make rules and regulations for general practice, and procedure of Supreme Court. Okay, so Supreme Court, according to Article 145, Supreme Court, with the approval of President of India, okay, they can make rules and regulations for general practice as well as procedure of Supreme Court. Okay, this is how procedure of Supreme Court is being framed in India. Okay, Supreme Court, with the approval of President, okay, they can make rules and regulations for general practice as well as procedure of Supreme Court. Okay, so this is the first power of Supreme Court, procedure of Supreme Court. We have discussed this. Now, next we are going to discuss the jurisdiction of Supreme Court. Next we are going to discuss jurisdiction of Supreme Court. Okay. Now, see here, in jurisdiction of Supreme Court. In jurisdiction of Supreme Court, okay, it is given from Article 131 to Article 143. Okay, the jurisdiction of Supreme Court is given from Article 131 to Article 143. Now, jurisdiction of Supreme Court can be divided into original jurisdiction. Okay, the jurisdiction of Supreme Court can be divided into a original jurisdiction, writ jurisdiction, okay, appellate jurisdiction, advisory jurisdiction. Okay, so these are the different types of jurisdictions that is given to Supreme Court. Okay, this is given in Article 131. Original jurisdiction is given in Article 131. Writ jurisdiction, as you all know, is given in Article 32. Appellate jurisdiction, it is discussed from Article 132 to Article 137. Okay, it is given from Article 132 to Article 137. Now, advisory jurisdiction, it is given in Article 143. It is given in Article 143. Now, we will discuss each and every individual jurisdiction in an in-depth manner right now. Okay, we will discuss all these individual jurisdictions in a very in-depth manner. Now, let's take a look at the first jurisdiction. Okay, the first jurisdiction that we are going to discuss today is original jurisdiction. Original jurisdiction, which is given in Article 130, which is given in Article 131. See here, according to original jurisdiction of Supreme Court, according to Article 131, the original jurisdiction of Supreme Court will extend to disputes between central government and state government, between state government and state government, and then central government and state government on the one hand versus state government on the other hand. Okay, so these are the types of disputes that will come under the original jurisdiction of Supreme Court. Okay, so these are what? These are federal disputes. These are federal disputes. Okay, these are federal disputes. Now, importantly, these federal disputes is an exclusive jurisdiction of Supreme Court. It's an exclusive jurisdiction of Supreme Court. What is the meaning of exclusive jurisdiction? The meaning of exclusive jurisdiction is that these cases can be filed only in Supreme Court. It cannot be filed in any other court in India. Clear? these federal disputes, it can be filed only in Supreme Court. It cannot be filed in any other court. See, why is High Court is not given original jurisdiction over federal court? The reason is here. See here, if this is India, this is Tamil Nadu, and this is Kerala. Now the power of High Court, Madras High Court, it will extend only to Tamil Nadu state as well as Puducherry. The power of Madras High Court, it will extend only to the state of Tamil Nadu as well as Puducherry. The power of High Court of Madras, it will not extend to Kerala. So if Madras High Court is deciding on the dispute between Tamil Nadu and Kerala, they cannot enforce their jurisdiction, they cannot enforce their judgment, right? They cannot enforce their judgment. High Court, Madras High Court, they cannot enforce their judgment because Kerala territory is outside the jurisdiction of High Court itself. Okay, so that's why with regards to federal disputes, now Himanshu, from Article 138 to 142, it is not 142. I'll explain. Article 138 to 141, it is not required for UPSC. Okay, it is not important for UPSC, so that's what I'm not going to discuss. Article 142, I'll explain. So that's why high courts will not decide upon federal disputes. Only Supreme Court has a power to decide over federal disputes. But even though federal disputes are given to the jurisdiction of Supreme Court, okay, Article 131 does not extend to Article 131 does not extend to certain forms of federal disputes. Article 131 does not extend to certain form of federal disputes. Those disputes include a dispute arising out of pre-constitutional treaty, engagement, or other similar arrangement which bars Supreme Court dispute in treaty or agreement which bars Supreme Court, okay. Another one is interstate water dispute, matters referred to Supreme Court, matters referred to Finance Commission by President of India, recovery of damages by state government from central government, okay. So these are the matters that are excluded from the jurisdiction of Article 131, okay. These are the disputes that are excluded from the jurisdiction of Article 131, okay. Is it clear, everyone? Is it clear? Did you understand? Okay, please, if you understand, please say right now in the chat section, or else I will move on to the next jurisdiction. That is writ jurisdiction. Okay, since no one has asked any doubts, I've assumed that you guys have understood, and I will move on to the next jurisdiction, that is writ jurisdiction. See, writ jurisdiction is nothing but, okay, it is nothing but another form of original jurisdiction. It is nothing but another form of original jurisdiction. What is the meaning of original jurisdiction? What is the meaning of the word original? The word meaning original is that the case has to freshly originate in that particular case. Sorry, a particular case has to freshly originate in that particular court. That is the meaning of original jurisdiction. For the first time, in the first instance itself, that particular case has to originate in that court. So writ jurisdiction, okay, in case of writ jurisdiction, to enforce fundamental rights, okay, to enforce fundamental rights, Indian citizens are empowered to use writ jurisdiction. Indian citizens are empowered to use writ jurisdiction. Now this writ jurisdiction is enforced by using four writs. Okay, this writ jurisdiction is enforced by using four writs. The first one is the writ of habeas corpus. The writ of habeas corpus. Next one is mandamus certiorari quo warranto. Sorry, five writs. Next one is prohibition. Prohibition. I don't know why I can't write here. Okay, prohibition. So these are the five types of writs that can be issued by Supreme Court for enforcement of fundamental rights. Okay, habeas corpus, mandamus, certiorari, quo warranto, and then prohibition. Okay, so these individual writs we have discussed in our fundamental rights class itself. So I'm not going to delve much deeper into this individual writs. Okay, I'm not going to dwell individually into what are these writs. Okay, we have learned all these writs individually in fundamental rights class itself. Okay, so keep this in mind. Writ jurisdiction is another form of original jurisdiction of Supreme Court of India. They are used to enforce fundamental rights. Okay, so to enforce fundamental rights, Supreme Court is empowered to issue five kinds of writs. Those include habeas corpus, mandamus, certiorari, quo warranto, as well as prohibition. Okay. Now, writ jurisdiction. Okay, writ jurisdiction. If individual is approaching Supreme Court, under Article 32, Supreme Court cannot refuse. Supreme Court cannot refuse cases filed under Article 32. Supreme Court cannot refuse cases filed under Article 32. And also, Parliament is empowered to give writ jurisdiction to any other court in India. Writ jurisdiction to any other court in India. Parliament is empowered to give writ jurisdiction to any other court in India. So this is with regards to writ jurisdiction, everyone. Now let's move on to the next part. Next jurisdiction of Supreme Court. Okay, the next one is appellate jurisdiction. The next one is appellate jurisdiction. As I mentioned before itself, appellate jurisdiction, it is given from Article 132 to Article 137. Okay, it is given from Article 132 to Article 137. Now there are different types of appellate jurisdiction. There are different types of appellate jurisdiction. Okay, so appellate jurisdictions regarding constitutional matters. Appellate jurisdiction regarding constitutional matters. It is given in Article 132. Okay, next one is regarding civil matters. It is given in Article 133. Okay, next one is matters regarding criminal matters. Regarding criminal matters, which is given in Article 134. Okay, and then appeals by means of special leave petition. Appeals by means of special leave petition, which is given in Article 136. Okay, and then appeals to Supreme Court judgment itself. Supreme Court judgment itself. Okay, this is also called as curative petition. Okay, it is given in Article 137. Okay, it is given. It is called. It is another name for appeal of Supreme Court judgment is called as curative petition. Okay, this is another name for this appeal is curative petition. Okay, so these are the different types of appeals that are appellate jurisdiction that are given to Supreme Court of India. Okay, now the first one is Article 132. Okay, Article 132. So Article 132 discuss about appeals regarding constitutional matters, right? It discusses appeals regarding constitutional matters. Here if any case involves constitutional and if any case involves constitutional importance as well as interpretation, that case can be appealed. That case can be appealed before Supreme Court. Okay, that case can be appealed before Supreme Court from High Court. All right. If any case in High Court, it deals with cases which involves constitutional importance as well as interpretation, that case can be appealed in Supreme Court. Okay, so this is Article 132. Now the next one is Article 133. Article 133 discusses with cases regarding civil matters, cases involving in civil matters. Okay, so if similar to Article 132, if any civil case discusses, okay, it has huge implications on constitution. If any civil case has huge implication on constitution or interpretation of constitution, constitution, okay, that case, okay, if any case now, Himanshu, sorry, I cannot explain this, but it's okay. I have at 11 o'clock I have to go outside. Okay, so I'm hard pressed for a time, so I cannot explain this bit jurisdiction. I have taken a separate class on fundamental rights itself. Just go and look at past Unacademy videos in YouTube. Okay, so you will come across class regarding fundamental rights from me. Okay, so please go through that, where I will explain writ jurisdiction in very detail. Now, if any civil case involves the question of constitution as well as interpretation of constitution itself, that case can be filed before, that case can be appealed before Supreme Court. That case can be appealed before Supreme Court. Okay. Now, the next article that we're going to discuss is Article 134. That is cases involving criminal matters. Cases involving criminal matters. See here, criminal matters, okay, criminal matters are worthy to be appealed from High Court to Supreme Court. Okay, okay, the criminal matters are worthy of appeal from High Court to Supreme Court in three instances. One, if it is certified by High Court that it can be filed before Supreme Court. Okay, if it is certified by High Court that this criminal case can be filed before Supreme Court, in that case, that particular case can be filed before Supreme Court. Or if any acquitted person, is given with death sentence, okay, so a previously acquitted person from district court is given death sentence by High Court. These cases are worth appealing in Supreme Court. Okay, or if High Court acquits death sentence, or if High Court acquits death sentence of a person. So in these scenarios, a case can be appealed from High Court to Supreme Court. Okay, in these scenarios, a case can be filed from High Court to Supreme Court. Now, the next type of jurisdiction that we are going to discuss, next type of appellate jurisdiction that we are going to discuss is appellate jurisdiction regarding special leave petition. Appeals by means of special leave petition. Appeals by means of special leave petition. See here, apart from other appellate matters, apart from other appellate jurisdiction like criminal matters, civil case, as well as constitutional cases, okay, any matter, okay, any case from any court, any case from any court and tribunal, any case from any court and tribunal can be filed before, can be appealed before Supreme Court, can be appealed before Supreme Court by special leave petition, can be appealed before Supreme Court by means of special leave petition. Okay, so what happens is that a person will will file special leave petition, before Supreme Court. Okay, before Supreme Court, and Supreme Court, a judge of Supreme Court, okay, it's a judge of Supreme Court, he will review this special leave petition, he will review this special leave petition. But in review, what will he do? He will examine whether this particular case is fit for appeal in Supreme Court or not. Okay, he will determine whether this case is fit for appeal in Supreme Court or not. He will examine also whether the principles of natural justice are being violated, or if any new evidence has come to light. All these things he will look into that. So after looking at all these things, he will, by means of special leave petition, he will admit some cases into appeal of Supreme Court. Okay, so that is appeal by means of special leave petition, everyone. Okay, by using special leave petition, any case from any court or tribunal can be filed before Supreme Court by means of a special leave petition. Okay, so that's why if you look at Kaveri dispute and all, if you look at Kaveri dispute and all, in Kaveri dispute, the judgment was given by Interstate Water Dispute Tribunal. Okay, as you all know, judgments from Interstate Water Dispute Tribunal cannot be filed before Supreme Court, but nonetheless, the Kaveri dispute is before Supreme Court. Why? Because this case was filed before Supreme Court using special leave petition. Okay, even with matters that are outside the jurisdiction of Supreme Court can be admitted into Supreme Court by using special leave petition. Okay, did you understand, everyone? Did you understand? If you have understood, okay, if you are not understood, please ask your doubts right now. Okay, after that I am going to move on to the next part. Please ask your doubts after that. After that I am going to move on to the next part. See here, using curative petition, any judgment of Supreme Court, can be appealed using appealed using curative petition, but if curative petition is being allowed, if it is being allowed to use very laxfully, what will happen? All judgments of Supreme Court will be filed using curative petition, right? If it is allowed to, if an individual is filed to allow all cases of Supreme Court using curative petition, then almost all cases will be filed using curative petition. Then it will increase the burden of Supreme Court, right? So to restrict, okay, according to Supreme Court, according to Constitution, the curative petition should be only used during extraordinary circumstances. This curative petition should be used only during extraordinary circumstances. It should be used only during extraordinary circumstances. Okay, so to file, okay, since it can be filed only during the last resort, there are a number of safeguards that have been placed for filing of curative petition. See here, if a person wants to file a curative petition, okay, this curative petition has to be approved by, first it has to be approved by a senior judge of Supreme Court. It has to be approved by a senior judge of Supreme Court. After his approval, it will go to a judge. This curative petition will be submitted before judge of the original bench. It will be submitted before a judge of the original bench itself. Okay, it will be submitted before the judge of original bench. Okay, now this judge will will take a look at this security petition, and he will examine whether the principles of natural justice was violated. He will examine whether the principles of natural justice have been violated, or if new evidence has come to light, So based on these two circumstances, he will examine this curative petition. Okay, he will examine this curative petition. Now, if the judge does not feel that this curative petition has enough grounds to be filed, he can impose penalty. He can impose penalty on the petitioner. He can impose the penalty on the petitioner for wasting the time of Supreme Court judges. Okay, so he can impose the penalty on petitioners for wasting the time of judges of Supreme Court. Okay, so this is how curative petition will operate. Now, once this judge has given his approval, this curative petition, this will be taken up by a bench. It will be taken up by a bench. This bench will give its judgment. Okay, so this is how curative petition operates. So this is how curative petition works, everyone. As I mentioned before, curative petition will be used by Indian Constitution only during last resort. Okay, so there have been number of safeguards that have been implemented. First, a curative petition has to be get approved by a senior judge of Supreme Court. After that, a judge of the original bench will examine whether the Supreme Court has violated national justice principles or not, or if any new evidence has come to light. And if he feels that the curative petition is not worthy of review, he can also impose penalty on the petitioner for wasting the Supreme Court's time. And after this judge accepts this curative petition, this curative petition will go before a bench of Supreme Court, and that bench will give its judgment. Okay. So now we have discussed that two types of jurisdiction. Okay, original jurisdiction as well as apparent jurisdiction and then bridge jurisdiction. Now in all these jurisdictions, Supreme Court is giving judgments. Okay, Supreme Court is giving judgments. Now, what gives the power of Supreme Court judgment to be implemented? I'll be making myself clear. So which provision in Indian Constitution makes that the judgment of Supreme Court should be implemented by all the courts in India? Which provision gives you that? See here, Article 142. If you look at Article 142 says that Supreme Court judgment, okay, Supreme Court judgment should be enforced by, all the other courts within the territory of India. Should be enforced by all the other courts within the territory of and then Supreme Court judgment also should be enforced by other organs of the government. What are the other organs of the government? It is executive as well as legislature. Okay, so according to Article 142, a Supreme Court judgment, it has to be enforced by all the other courts within the territory of India, and it should be enforced by all the other organs of the government. Now, what happens if Article 142 is not there? What happens if Article 142 is not there? If Article 142 is not there, what will happen? Supreme Court judgment is only for namesake. No one will enforce Supreme Court judgment. Okay, so that's the problem here. So that's why Article 142 is there, so that we can make sure that all the judgments given by Supreme Court is being enforced by other courts as well as other organs of the government. Okay. Now the next jurisdiction that we are going to discuss is advisory jurisdiction. Advisory jurisdiction. See here, advisory jurisdiction is given in Article 143. It is given in Article 143, and now there are two types of advisory jurisdiction which is given in Article 143. One is according to Article 143 Clause 1. Another one is according to Article 143 Clause 2. Okay. So according to Clause 1, if President refers any matter, to Supreme Court, okay, if President refers any matter to Supreme Court, then Supreme Court can either accept or reject this particular matter. Supreme Court has a choice of whether accepting this particular case or rejecting this particular case. But if President refers any matter to Supreme Court, In case of pre-constitutional treaty, in matters regarding pre-constitutional treaty, then Supreme Court has to compulsorily accept this particular case. Okay, then Supreme Court has to compulsorily accept this particular case. Now, why pre-constitutional treaty? Supreme Court has to compulsorily accept this particular case. See here, in Article 131 itself, I explained. See, in Article 131 itself, I have explained that a dispute arising out of pre-constitutional treaty is exempted out of original jurisdiction of Supreme Court. So, if there is any dispute regarding that, okay, there is no other way to get the opinion of Supreme Court other than advisory jurisdiction. Okay, there is no other way to get the opinion of judiciary of India regarding pre-constitutional duty except using advisory jurisdiction. So that's why Supreme Court has to compulsorily accept this matter. Now, Supreme Court once accepted this, once they accept this matter from President of India, Supreme Court will form a bench. Okay, Supreme Court, they will form a bench. They will form a bench and they will take up this matter, and this bench will give their recommendation. This bench, they will give their recommendation to President. Okay. Now this recommendation is only advisory. This recommendation is only advisory. What is the meaning of advisory? It is not binding on President of India. It is not binding upon President of India. That's why it is called as advisory jurisdiction. Okay. That's why it is called as advisory jurisdiction. Now this recommendation is not subject to judicial review. It is not subject to, not judicial review. It is not subject to a reconsideration of Supreme Court. Okay, this recommendation given by Supreme Court on any particular matter to President of India is not subject to reconsideration of Supreme Court. Okay, so this is advisory jurisdiction, everyone. This is advisory jurisdiction. Now there are two clauses within advisory jurisdiction. One is clause 1, another one is clause 2. According to clause 1, President can refer any matter to Supreme Court of India, and Supreme Court can either accept or reject this matter. Okay, now if President refers any matter regarding pre-constitutional treaty to Supreme Court, then Supreme Court has to compulsorily give its advice. Okay, so if once Supreme Court has accepted this matter from President of India, Supreme Court will form a bench, and then Supreme Court will give its recommendation or opinion to President of India. Now this recommendation or opinion is only advisory in nature, and it is not subject to reconsideration of Supreme Court. Okay. Now the next one is Supreme Court as court of record. Supreme Court as court of record. This is given in Article 130. It is given in Article 130. Since Supreme Court, okay, since Supreme Court, see, according to not 130, according to Article 129, according to Article 129, okay, see, according to Article 129, Supreme Court acts as court of record. Supreme Court acts as court of record. What is the meaning of court of record? Which means that Supreme Court judgments are recorded. Supreme Court judgments are recorded for perpetual memory. They are recorded for perpetual memory. And testing, they are used for, and they are also used as evidence in lower courts. They are also used as evidence in lower courts. Okay, and then a Supreme Court judgment will be treated as a legal proceeding or precedent. Okay, a Supreme Court judgment will be treated as a legal precedent or legal proceeding. Okay, so this is the power of court of record of Supreme Court. Okay, since so Supreme Court is considered as court of record. Okay, court of record of Supreme Court is recorded for perpetual memory as well as testing, which can be used as evidence in lower courts, and Supreme Court judgments is treated as legal proceeding or legal precedent themselves. Okay, and then Supreme Court also has the power of contempt. Okay, Supreme Court has also the power of contempt. Okay, so Supreme Court can use the power of contempt. Okay, power of contempt against individuals, okay, who undermine the authority of Supreme Court or act in a way which is prejudicial to a case in Supreme Court, prejudicial to a case in Supreme Court. Okay. Now this power of contempt, there are two types of power of contempt. Yeah? There are two types of power of contempt. One is contempt regarding civil matters, and another one is criminal matters. Contempt regarding civil matters as well as criminal matters. Okay, this is power of contempt. So Supreme Court, if they feel that if the individual is undermining the authority of Supreme Court, or if he is acting in any way prejudicial to a case in Supreme Court, then Supreme Court can file this contempt case against an individual. Okay, now this power of contempt can taken up by Supreme Court in suo motu. Can taken up by Supreme Court suo motu. What is the meaning of suo motu? Supreme Court itself can take up this case without anyone filing a petition. Supreme Court itself can take up this case before Supreme Court and initiate contempt proceedings. Okay. Okay, everyone. Now the last powers and function of Supreme Court is the power of judicial review. The power of judicial review. The last power and function of Supreme Court is the power of judicial review. See, according to Constitution, the power of examining the constitutionality of legislation and executive orders of central government and state government. Okay, so based on this power of judicial review, Supreme Court has a power of examining constitutionality of legality of executive orders as well as legislation of both central government as well as state government. Okay, this is the power of judicial review which is given to Supreme Court of India. Okay, so that's it, everyone. Okay, that's it, everyone. We have completed today's class. Okay, so we have discussed everything about the powers and functions of Supreme Court. Okay, we have discussed everything about powers and functions of Supreme Court. Okay, now mind you, now the nature of Supreme Court I have discussed in my previous class. Okay, I have discussed in my previous class. So if you wish to know, if you wish to learn about that class as well, go back and rewatch that particular class. Okay. Now, people, if you have any doubts so far, please ask your doubts. I will give you 2 minutes to ask your doubts. After that, I'm going to end the session. People, if you have any doubts, please ask your doubts right now. After that, I'm going to